So I think we are quite settled. Quite a few people have joined us. I will just okay. Now we can start. Well, thank you so much, everyone, for joining us. I'm so glad to have you here. I would like to welcome you to our webinar and / Q&A. So today we're going to talk about the upcoming law changes in the Estonian legislation, which are going to happen next year. And we have a corporate lawyer, Georgi, joining us today to answer all your questions and to give you an overview. And also feel free to ask any questions in the Zoom chat or in our LinkedIn Live page, so in the comments section. So we are so happy to have you here. And before we begin, just a little bit of an overview of Silva Hunt and why we organized this. Basically, we are experts in the Estonian business law, and also we provide services to e-residents who have more demanding needs, who want to form a company in Estonia, who want some help with accounting, taxes, not only taxes in Estonia, but international tax advising is something we offer. So if that's something you're interested, feel free to contact us afterwards. And also, we really value networking. We organize networking events for our clients, and we really love this matchmaking. So feel free to network with us on LinkedIn as well. And yeah, with further ado, please, Georgi, introduce yourself and say what are the main changes that are going to take place next year.
Hi everyone, my name is Georgi Jeniashvili. I'm a lawyer, Estonian lawyer. I practice for 10 years in the field of corporate law, employment law, contracts and taxation. I daily work with the startups, so I think I can help you all with these questions that you will ask in the chat or after. So the commercial code will change in the next year, and not only. The first main change is that we will have the new legislation about commercial registry. It's called Commercial Registry Act. So this act will stipulate the data composition of the business register. It will regulate the procedure of making entries, and will keep this registry and supervise it. So the law will be changed in a lot. So there are a lot of changes, about 45 pages of changes I read before this webinar. So I will talk about the basic ones that you need to know. Other are specific. So if you will be curious about them, you can ask Silva Hunt or me afterwards. So maybe you already heard that from the next year, you can register your company without the share capital. What does it mean? That you can incorporate it with the minimum amount. The minimum amount of one share is 1 euro. So nowadays you can, as a natural person, register company without the share capital. So you just mark it that your share capital is 2,500 euros, and you can pay it in 2-3 years as you agree with other shareholders in the Articles of Association. But from the February next year, you should pay only 1 euro. This is the minimum, but you should decide by yourself. If you want to make the share capital, for example, 100, 200, 1,000, 5,000, it's only up to you. The second main change is that you can you can book your the commercial name of your company for 6 months. This is the paid service. The state fee will be about 150 euros. And also you can apply that application to make any entry will be on the specific date. For example, you want to change the list of shareholders or change the management board members 2 months after, but you want to make this changes application now, but it will go to the public only in 2 months, so you can save this date. But you should not only decide that you want this, but also you should specify why it's needed to the commercial registry. The next change is about the annual report. In Estonia, we have a lot of companies that fail to submit the annual report on time, so they received from time to time the fines or the notification from the commercial registry that they need to submit the annual report immediately. So what will be changed with this? With the new regulation allows a fine to be imposed on a legal entity that has not submitted its annual report by the deadline without issuing a warning order. So today you will receive the warning or notification, and after that only you will receive the fine. But from the February, you don't be surprised if you receive firstly the fine, not the notification. So this is very important to because of transparency of the Estonian legal system, because the annual report should be submitted on time, even if you don't operate. So for example, you registered your company last year or this year and didn't start operation, and you have like zero income, zero costs and other transfers. So in this case, you also need to submit the annual report, and it's easy. Or you only should write that you had the zero amount on your bank account. About fines, that when the register will impose a fine, they have their own discretion. The amount of this fine will be at maximum, it will be at minimum. Another change in the legislation is about I have a list of these changes, so I need to decide what what I will talk with you.
What will affect e-residents the most, and especially tell me a little bit how will it affect e-residents who already have companies? So for example, if they have formed a company in Estonia but they haven't paid in the share capital yet, will they also be able to put the share capital as €1?
No, for the companies that are already registered, it will be the same regulation like as now. So if you have registered the company without the share capital, you can transfer money only when you decide, like how it is written in your articles of association. The only change is that from the February of the next year, you can't register the company without the share capital. You should put any amount of money inside.
Okay, so €1 is the minimum, right?
€1, not euro, cents. So the main thing for e-residents states that the problem, what I see that with the bank account, because even to make this 1 euro transfer to the company, you need to open the bank account. And maybe, as you know, you don't need to have Estonian bank account for Estonian company. For example, if you're resident of Montenegro, you can try to open the bank account in your own bank when you have your own banking account, like a natural person, because they know you, they trust you. It's simpler to open the bank account for the legal entity for you.
It just needs to be in the European Economic Area. That's it.
Yes. It also can be the payment institution, but you should double check with your service provider if it's suitable or not.
But what about Wise or Revolut or other like fintechs?
Yes, nowadays Wise and Paysera, Revolut are working well with the Estonian commercial register. You can open an account there. It's pretty easy, and they issue this notification that you made the share capital contribution that is necessary to show to the commercial register.
Okay, but from the next year, I understand that if your share capital is under 50K, then you don't need to provide this.
Yes, so it will be easier for the entrepreneurs, so they don't need this notification, so they can try to open in another payment institution, but it should be at least trustable for you, like for entrepreneur. Also, I wanted to mention that as the share capital requirement will be lower for the new companies, that means that the amendment removes from the law the requirement that the net assets of a private limited company must be at least as large as minimum amount of the share capital of limited company. So, for example, now you have the share capital 2,500. Your net assets should be at least the same, equal. But from the February, this requirement will be removed. Also, there will be changes with the contact persons. So from the next year, you don't need the contact person if your legal address is in Estonia. But don't be in a hurry to terminate contracts with your contact persons, because they are the first persons who receive the notifications from the government, from the another persons. So this is the protective line for you as well, so you don't miss any notification, so that will cause any problem for you. Also, a lot of service providers that provide this contact person service, they provide legal address service that is included in one package. As I know, Silverhunt provides it.
Yeah. Yes, of course. And also, I'd like to mention briefly that from next year, as Georgi said, you don't need this legal address in Estonia, which means you can use your foreign address. But if you want to build more substance in Estonia, maybe get a bank account here, or avoid having a permanent establishment in whatever country, then it's always better to have a local address.
Also, the benefit to have this contact person in Estonia is that with the new regulation, the registrar may note the difficulty of contacting a legal person and disclose it in the e-business register. So your future partner or any other supplier or buyer can see that it is hard to contact with you, even for government, so they won't do business with you. So the contact person will save your risk in this matter. So don't run and don't cancel all contact person contracts. you should know what risks you have, and I think as Silverhunt has this in one package, the legal address and contact person service. This is cheap risk management for you. Okay, the one of the greatest amendments in the law is also that if you want to liquidate your company, you should have the liquidator. But nowadays you should have liquidator who should be the Estonian resident. But from the next year, this requirement will be removed. So you as a foreigner can liquidate your company as well. But as you are not a specialist in Estonian legislation, and you don't know even Estonian maybe, so you can submit the documents in Estonian language. It's better to have the liquidator who is from Estonia and who has knowledge how to do this.
But also there was some kind of change with companies that are not active.
Yes, I will double check. Yes, so the limited liability company, like OU, may request the registrar to delete itself from the register if this company has not started operations. And this is confirmed by all board members and all shareholders. So you should prove that you have not started operations, that you had zero. I know some entrepreneurs or even people who wanted to create a startup in Estonia. They thought that they will do this like in 3 or 4 months, but after they decided to make another business or go to another jurisdiction or just to change partners, so it will be easy to delete this company. So these are the main changes that I saw, because another regarding the merger of the company and other legal acts of Estonia. So you can ask other questions if you have.
Yeah, feel free to submit your questions to the chat or to the LinkedIn Live. But prior to this webinar, some people also asked some questions, and one of the main questions was, is it beneficial for them to form a company right now or next year? Like, what are the disadvantages or advantages? What do you think, Georgi?
It depends on your business structure, what you want to do with your company. But you should notice that if you don't have money to pay the share capital, it's better to make it now as a natural person, because this requirement, this allowance to not pay the share capital now will exist until the 1st of February. And about this share capital, I wanted to mention that despite the small amount of the share capital that will be from the February, the liability of the shareholder remains similar to the current regime. So, for example, you went to the bankruptcy and your share capital is 100 euros. So your liability will be the spread between 100 and 2,500 euros as a shareholder. So so in bankruptcy, you should pay, for example, 2,400 additional to this pool to cover costs of the bankruptcy procedure. So if you don't want to risk with your liability, I suggest you to have this 2,500 share capital in the company.
Okay. So some people have submitted some questions. Kristi says, but if I don't have an operation yet, then I can remove the contact person and later I can add it again. Is it valid from 1st of February? Does she understand correctly?
It depends. Do you have the legal address in Estonia or not? From the February, you can remove the contact person if you have the legal address in Estonia.
Mm-hmm.
But if you don't have you have for your company's address is in another country, then I don't suggest you to do this, because the register can also remove your company from the register if you don't have a contact person if it's required.
So will all of these changes that you just talked about be in effect from the 1st of February, or do they have different dates?
Some of them have different dates. For example, this business name booking will be from the September or from the 2024. The annual report requirement is valid now, but this amendment will be in effect from the February as well. The share capital requirement will be valid from the February, and all that I mentioned basically there will be from the February.
Okay, so if someone was late with their annual report payment, like they had to do the annual report in July, for example, but they did it in December, will they get a fine for that in next year? No?
They will have fine before they submitted this annual report.
Okay,
For
okay.
example,
Before.
you have obligation if you have the regular calendar year for annual report, so you should submit it by the end of the June. For example, from August, the register will issue a fine for you that this deadline is missed. They do this nowadays as well, but firstly they send notification 1 and 2, and after this they send fine for the company, and then they send fine for the management board member. This is allowed because the management board member is obligated to submit this annual report. He's the person who should submit
Who's liable?
Yes, who is liable, who should sign it. So from the next year, you will not receive the notification. The first what you will receive will be fine, and after you will receive, for example, 5 notifications or fines, this will be also shown in the commercial registry. So other business participants can see this, and they will see that you are not trustable person with whom I can do business, for example.
Okay. I see Victoria has a question about shareholders list. Could you, Victoria, tell a bit what is your question?
Yes.
I don't understand.
This is also will be changed from the next year. So nowadays, the list of shareholders should be held by the management board member of the company. So that information that is in the commercial registry now, this is more informative. Not it can be changed in any way by the company, but not notified the commercial register. So you can trust this information for 100%. But from the next year, September, there will be a separate register in this commercial register of the shareholders. So if there is written that Dagne and Georgi are shareholders, this is the true information. And when you will sell the company, it will become in force only when the changes of the shareholders will be done in the register. For example, nowadays it is in force already when you sign this agreement at the notary. But from the September of the next year, it will be in effect only when the changes are done in the register.
Okay. Oliver has a few questions about the service provider. I will just give you a quick overview if you joined us later. Basically, from next year, it's possible to use a foreign address for your Estonian company. That's the main point. And Oliver is asking, does the legal address provider still need the license to be a service provider?
Of course, yes.
Yeah, so that is still a requirement. I also got a question that is not related directly to this topic, but I think it's good to answer it. It's been coming up with our clients a lot lately as well. So people want to understand why service providers need to do a KYC. So there's a question by Juan, what is the legal obligation of performing KYC to clients on the part of consultants helping out to establish a remote business in Estonia?
This is a requirement in accordance with the Money Laundering Act, prevention of the money laundering. So the contact persons that have this license, they are obligated to know who are their clients, where they receive money from. So this is for transparency of the Estonian legal and economic system. This is the requirement from the legal act. So you can't avoid this.
Okay.
So if the service provider won't do this, they will be fined, and after the license will be removed.
Next question is from Baha. If my Estonian company is providing a service of establishing companies in Estonia and it is outsourced to a company who got the license, should my company also provide license?
If your company is not acting as a contact, yeah, of course you need, because it depends on the business model as well. If you are just connecting this service provider who has a license and the client, it's okay, it's this agency relationship, you don't need the license. But if you provide a consultation about this, you help submit the documents, in this case you also need the license.
Oliver wants to ask by voice. Yeah, go ahead, Oliver.
Hi, it's easier to formulate a question by voice than writing.
Sure.
Regarding contact person and legal address, I understood that you can have your legal address abroad.
Yes.
If you have that, you need a contact person.
Yes.
Not. So if it's a Vienna company, for example, in Austria, put the legal address in Vienna, then you need to have an Estonian contact person.
Yes, but if you have Estonian legal address, you don't need the contact person.
Then you don't need the contact person. Okay, yes. And the legal address must be furnished by a provider which has the FU license.
It can be, for example, if you have an apartment in Estonia, it can be this address, or
if you own the apartment. But if you not own it yourself, so then you would go to somebody. You can go to
it's better to go somebody. Yes, because you can't register to the address that is, for example, you can't register my home address as your company address.
Okay, then you go to a provider like Silverhunt, and to deliver this legal address, they need to have the FU license.
Yes.
Okay, got it. Thanks.
Okay. Did we already touch the personal liability aspect? I think it's
yes, I mentioned about
it's important to understand that
the liability range is the same. So if something happens, you will have this liability in amount of 2,500. So if your share capital is the same, it's okay. The company will be liable for this amount. But if it's less, then you as a shareholder will be liable for the difference in this amount between your share capital and 2,500.
Could you elaborate a bit about the name as well? is it like, how does it work? Like, do you, when you form a company, can you already, before even the company exists, can you reserve that name, or do you need to create the company first and then like change the name and then reserve a new name?
If I remember correctly, it is when you want to change the name, because you can book the registration of the company.
So you need to have a company in order to even book the name. Okay, that's good to know. Okay, there's another question. And what about the communication through the national mailbox at eesti.ee? Can it be considered proper and substitution for a contact person?
The STA mailbox is the mailbox for the residents of Estonia, so it's not like a contact person's email. But if no contact person provides this email, it's email, it's okay. It doesn't depend which mailbox they have. So the main rule that the contact person should have the license and should be registered to the commercial register to your company.
Will the share capital contribution be available at the time of incorporation in the business registry as a startup account also, as it is used now for incorporation from legal persons?
I think this system will be the same for this for the starting account. But if you are not the resident of Estonia, it will be difficult to establish it. So you need to do this separately, to go to the bank with these papers of the documents of the company that it is in incorporation, pass the KYC and give another documentation to the bank, so they could open this starting account for you, so you can make the share capital contribution.
But the starting account can be in any European Economic Area, so it doesn't have to be Estonia.
Yes.
But it can it be also Wise, right? It can be Revolut or Wise as well, so that's not a problem.
Yes, that's not a problem.
That's good to know. So Alina says, now the system allows to create startup account if you have an Estonian personal code.
Yes. So that means that if you are resident or e-resident, sorry for misunderstanding.
Because e-residents also have a personal code.
Yes, but sometimes banks ask to come to verify their in person if they are not the permanent residents of Estonia.
Yep, and if it's fintech, then you don't have that problem.
Yes, they use another service providers for verification.
Yeah, that's why we also, most often our clients use Wise, and they have no problem. Everything is fast and really sufficient. Yes,
Paysera works very well in this case as well, in my experience.
I know that not all fintechs provide this a certificate to say that your share capital is registered, but this problem is going to be lost now because you don't need it. If your share capital is under 550K, that's when it will be applicable. So we are welcoming more questions if there are any. What can you briefly mention what will be the changes for merger and acquisition, or will there be like something that's going to make it easier?
No, there are the additional requirements that should be in the merger agreement, for example, about the accounting as well. So it will be a bit, it won't be difficult Scott, it's now in the in the same level as it will be. There will be just additional 5-6 requirements that you should add to your agreement and to the accounting system. So the lawyer or notary can help you with this.
Mm-hmm. Okay, I'm going to check for questions. How many changes were there in that document? So I understand that not all changes will directly influence e-residents.
Oh yes, the changes are written.
Are they only in Estonian or in English version as well?
I read only in Estonian because our main language in Estonia is Estonian, but maybe in a couple of months they will translate this new legal act about commercial register, because now it's only in Estonian, as I see. Yes.
Yeah, we will also make a conclusive article about this topic. And yeah, also this webinar will be available on LinkedIn afterwards. You can watch the recording. We will send all the links and a small overview. But so far, what do you guys think? How do these changes look to you? Does it make it look easier in Estonia, in your opinion, or not? Let us know in the comments. What do you think, Georgi? Are things getting easier?
Somehow easier, somehow it's like hidden that it's shown as an easy way, but the responsibility of the shareholders of the company, for example, will be the same. So even if you have this small share capital, but for example, for the entrepreneur who wants to be a freelancer, it will be easier. So he or she can have this small amount of share capital. This investment is small for him or her, so it's easier. But as I think, if you will come to me and you want to provide freelance service or another service, and I will check your company, there will be written that you have share capital €1. I will think, should I work with you or not? Because maybe this is double risk for me, because your liability, you put it your liability so small. So you showed me that you want to be liable, that your company is liable for €1, for example, but you as a shareholder for a bigger amount. But it's also complicated to go to the court to take this money from you, because it takes time and resources.
But the process of when a company forms a company and the share capital is under 50K, then I see that is more faster and easier in that case.
Yes.
Gustavo Fröhlich asks, there will be any changes? There will be any changes for an already established company to open a WISE account next year?
The legislation have no words about WISE accounts or another accounts, so you can open next year, this year, the WISE account. It wasn't prohibited, and won't be, because the banks are too conservative, and the legislation allows you to open in payment institution the account and use it for your own purpose.
Oliver asks for the link of the changes. I think we will share it after the webinar. some kind of a conclusive overview, so you will get the info.
Mhm.
But all of these changes, will they usually they will be posted on the Estonian Tax and Customs Board, right?
No, they are posted in Riigiteate
Mm-hmm.
and also on the website eelnõud.riigikogu.ee. You can see they're all legislative acts that are now in Riigikogu and that are effective already, that they started to change any legislative act. So you can see all information there. But I think I will send this link to the Dagny. She will send all of you.
So I'm going to check if there's any questions on LinkedIn. So basically the companies that already exist, they don't have to do nothing.
Yeah.
Okay, that's good to know. So if guys don't have any more questions, I can conclude that next year things will be a bit easier, but a bit different as well. So the service provider aspect as well, you still like benefit from a service provider for sure. So I would highly consider getting a service provider and using the services, because still a lot of documents are in Estonian and you need a local confidant who can help you, such as Silva Hunt, for example. So we really take it seriously when it comes to personal service. You will have a dedicated person who will answer your questions. Not only that, you can have the networking benefits. We will organize some matchmaking events for you. So if that is something you are interested in, please feel free to write info@silvahunt.ee. And also to be our follower on LinkedIn as well, because we have next event coming up already in December, the 9th of December, about why form a startup in Estonia. So if that's a topic you're interested in, be sure to tune in. And yes, we will send you a follow-up email with the link that Georgi has, what Georgi has talked about. And yeah, be sure to stay in touch with us. Yeah, I loved having you here. And thank you, Georgi, for this overview.
Yes, thank you all for listening. And I want to add to your last comments that, in my opinion, it's better to pay to the service provider, lawyer, or accountant, or any other specialist, even 100 euros for a consultation before you do something. Because in my experience, the clients are coming when they messed up. They made everything that they could with a lot of mistakes, and then the service provider, lawyer, accountant, another specialist takes the more money from you because he or she should fix it. So the better ask before and do it in proper way.
Yes, wise words.
So but nobody listens this.
Okay, thank you so much. Have a nice day.
Bye.
Bye.